A lawyer can work for an hourly rate or flat fee on a legal matter. However, many represent clients on a contingency fee agreement. Under this kind of fee agreement, legal fees are paid to the attorney only if the attorney wins money for you. Contingency agreements are common when a lawyer agrees to represent a client and go after money from who is at fault. The type of lawsuit can be anything from a car accident, breach of contract, an insurance company not acting in good faith, to almost any other type of case where one is victimized. So sometimes, when you need legal help and can't afford to pay for it up front, a contingency fee agreement can greatly help your circumstances. Fortunately, there are many law firms which exclusively use this fee arrangement in a variety of legal matters. You can discuss a fee reduction at the initial consultation because you may not be able to negotiate lower fees after you've already signed a contract. Knowing how to better negotiate a contingency fee agreement can save hundreds, thousands, and possibly millions of dollars. Because rarely will an attorney or any other professional offer to reduce their fees. However, in most cases, a contingency agreement must express that the attorney's fee is negotiable between the attorney and the client, not set by any legal statute or law. In other words, the law is designed to promote negotiated contingency fees. In this series, we educate you on 2 ways to negotiate lower fees. First, understanding the 3 elements of a high-value contingency case, which sheds light on what a lawyer is looking for in a contingency case. Second is all about the sliding scale. So let's get started.